Hey, everybody, here, Mark Moisier, attorney in the state of California, who focuses on constitutional law, election law, and political law. And this morning, I woke up with the news about a Florida pastor who was arrested for holding a church service yesterday in Tampa. And like like most of you, I had to read up on it, but then I went and actually started to do some legal research. Now, I haven't finished all my legal research, but I did want to jump online and share with you what I have seen and maybe answer some of the questions that I've been seeing being spread around the internet. Doesn't this violate First Amendment rights? Did they have the right to do this? And so I'm going to spend the next couple minutes talking about this Florida pastor and the implications of First Amendment law and actually Florida statute. So let's dig in. The First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, the Supreme Court and the federal courts have constantly held that that there's two concepts here: the freedom to believe and the freedom to act. And while the courts cannot disturb your freedom to believe, there are certain restrictions on your freedom to act. Case in point, when the Mormons were in Utah trying to get Utah to become a state, the Supreme Court said that the United States government could restrict them from becoming a state because they practice polygamy. Also, the courts have held that, just because a church wants to have a parade down the middle of Main Street does not stop the city from requiring that they first get a permit. There are allowed to be certain reasonable restrictions to your exercise of religion. However, in a very important case that happened during World War II, in the case called West Virginia State Board of Education versus Barnett, the Supreme Court dealt with the issue of whether the courts or whether the state could require Jehovah's Witnesses to pledge allegiance to the United States. This is one of the pledge cases. And the court came down with a very important ruling, which I think is very important for the issue of this pastor in Tampa. And I'm going to read this ruling to you here real quick. It says, the right of a state to regulate, for example, a public utility may well include, so far as the due process test is concerned, power to impose all of the restrictions which a legislature may have a rational basis for adopting. Court basically saying, hey, if you're regulating, government just needs a reasonable basis. But freedoms of speech and of press, of assembly, and of worship may not be infringed on such slender grounds. What does that mean? It means reasonableness is not sufficient when you're violating somebody's exercise of religion. So the court continues, they are susceptible of restriction only to prevent grave and immediate danger to interest which the state may lawfully protect. What we learn in this important case is that the state has to articulate grave and immediate danger to the public. So the question becomes, can the Tampa police or the sheriff of Hillsborough County articulate a grave and immediate threat to the people of the county that allows them to restrict people's ability to freely exercise their religion? And this is going to be a very interesting question. It's one that I haven't finished my legal research on, but I think that the county of Hillsborough and the city of Tampa have some serious problems of overcoming this particular requirement, that they have to prove that there's grave and immediate danger to the people by stopping this church from having its services. So let's continue, because that's not it. As I dug into this, I realized that the governor of the state of Florida had actually passed an executive order. And in that executive order, he shut down the beaches. He shut down bars. He shut down restaurants. But he did not shut down the churches. And a question that I have is that this statute that gave the governor the authority to issue, or what he says, issue such, quarantines, shelter-in-place laws, this is the same statute that the county has. Now, again, I'm not a Florida attorney. I have not looked at this, but I know that a state cannot pass a law that contradicts what Congress has said. And so if Congress has already regulated in an area, a state Congress has said. And so if Congress has already regulated in an area, a state cannot come in and pass their own contrary regulations. And so I'm very interested, and I think it's some research that needs to be done by a Florida attorney, is whether a county can come in and issue a contrary executive order that's contrary to what the governor issued. The governor said nothing about churches, but the county came in and issued even more restrictive rules. And so I'm very interested to see if there is an overstepping of authority in the county of Hillsborough in Florida. The third area that I looked at dealt with what authority is even given to quarantine or isolate individuals in the state of Florida. This is not the first time we've had pandemics. And so the legislatures actually looked at these issues and said, if we have a pandemic, if there is a state of emergency, this is the authority we are going to give to our public health authorities. And so I went and I looked at what that authority says. And this is Florida Statute 381.00315. And in it, it gives the authority to state public health authorities to quarantine and to isolate individuals when they believe that there is a serious cause of mortal injury. But it's very interesting, because when you actually look at the word isolation, what does that mean? Because the statute actually defines what isolation means. Isolation means the separation of an individual who is reasonably believed to be infected with a disease from individuals who are not infected. Thus, public health authorities under a state of an emergency are allowed to come in and say, you are infected with a disease. And in order to protect those who do not have the disease, we are going to isolate you from everybody. The public, or the Florida legislature, under a state of emergency, has granted permission to state health officials to basically isolate anybody who has a disease under a state of emergency. But remember, they also have the authority to quarantine somebody. And quarantine also has a very explicit definition in Florida. It means the separation of an individual reasonably believed to have been exposed to a communicable disease, but who is not yet ill, from individuals who have not been so exposed, to prevent the possible spread of the disease. As such, in the state of Florida, if the public health authorities working under their state of emergency powers has reason to believe that you have been around somebody who has the disease, they can quarantine you from those who do not. But they have to come in and prove that they reasonably believe that you have been around those who have the disease. I believe that the county of Hillsborough has failed to properly articulate that they have a reasonable belief that that everybody who went to this pastor's church had been around somebody who had the disease. And as such, they had the right to quarantine them or isolate them and mandate that they shelter in place. As I said, I am not a Florida attorney and I cannot give you Florida legal advice. I'm just an attorney who's looking at this issue. And if I were in the position of advising this pastor, which I'm not, there would be three areas that I would be looking at. Number one, has this violated his First Amendment right to freely exercise his religion? And I think the state may have some serious problems. I think the police have some serious problems in this ground. Also, I'd be looking at, is there a conflict of interest by the county passing different ordinances under a state of emergency than what have been passed by the governor over this very county? And then I would also be looking at the third area of whether the county has exceeded its authority under a state of emergency to quarantine and isolate people who they cannot reasonably articulate have actually been in contact with the disease. As such, I think the pastor has some pretty strong legal arguments that he is going to be allowed to make when he comes to make his defense. This does not include his due process rights and equal protection and many other constitutional arguments that he is going to be able to make. This is going to be very interesting to watch how this plays out in the court in the months and maybe even years to come. As I said, this is not the first time this nation has faced a pandemic, and the legislatures have passed laws in what the government can do under these circumstances. And if the government exceeds its authority, they are going to be held liable for their violations. Hey, everybody. My name is Mark Moiser. I'm an attorney in the state of California, and I'm fighting to help educate you on what your rights are, what the government has the authority to do, so that way you can be a better citizen as we all survive the panic of 2020, which is the coronavirus scare. Until next time, please remember, let's be safe, let's be prudent, but let's not check our rights in at the door just because some politician wants to deprive you of them in the name of safety and expediency. Talk to you later.